Hello, my name is Tom Mooney. I'm an Associate Solicitor at Stevenson's, and part of my caseload includes professional negligence claims arising from mistakes other solicitors have made when investigating clinical negligence claims. Patients put their trust in medical practitioners to appropriately diagnose and treat their problems. If a patient believes that the medical treatment they've received has been below a reasonable standard of care, then it is appropriate for them to take legal advice. And in some situations, it is reasonable for them to investigate a claim for potential clinical negligence. When bringing a claim for clinical negligence, the client puts their trust in a professional once more, this time their solicitor, to appropriately investigate their complaints. Unfortunately, solicitors can also make mistakes, and this can lead to clients being undercompensated, or worse, not compensated at all. Today I'd like to discuss 3 common situations where clinical negligence solicitors can sometimes fail their clients. A common mistake is for solicitors to fail to start claims at court in time. The general rule is that claims should be started at court within 3 years of the alleged negligence. If a claim is not started at court within the set times, then it is possible, if not likely, that a court will decide that a client is barred from pursuing the claim any further. When a claim is started successfully at court, then a timetable is set to ensure that a claim progresses expeditiously. Deadlines might include deadlines to serve witness evidence, expert evidence, or documents upon which a client intends to rely. If the deadlines are not met, then this can have a significant impact, as a client might not be allowed to rely on certain evidence or certain experts. This could lead to a claim being unsuccessful, or a client receiving less compensation than they otherwise would have received. During the course of a clinical negligence claim, it is often necessary to obtain expert evidence from independent specialist medical professionals. The choice of expert and the choice of specialism is very important in determining the value and prospects of a claim. It's extremely unfortunate when clients are mistakenly advised that their claim no longer enjoys reasonable prospects simply because a clinical negligence solicitor has not instructed an expert from an appropriate specialism. Often by the time the mistake is noted, the client is out of time to instruct an alternative solicitor to pursue the action any further. Sometimes clinical negligence solicitors fail to consider all possible heads of loss, and this can lead to claims being undervalued or more significantly undersettled. I say more significantly because once claims are settled, it is often not possible to return to the paying party to request additional funds. Sometimes losses are obvious. For instance, if a client has suffered loss of earnings, then it's clearly appropriate for them to be compensated for this loss. However, losses might not be as clear-cut. For example, it is possible that a clinical negligence solicitor might fail to take into account the psychological impact that the medical negligence has had on their clients. It is possible that a clinical negligence solicitor might fail to take into account the care and assistance that a client has required or will require in the future, even if the care and assistance to date has been provided by a loved one and not by a paid carer. It's also possible that a clinical negligence solicitor might fail to take into account future loss of earnings should a client lose their job and find it more difficult than otherwise they would have found it to get alternative employment as a result of possible physical limitations that they have as a result of the medical negligence. If your solicitor has made mistakes when conducting your clinical negligence claim and you have been undercompensated, then Stevenson's can help. As a firm with a specialist clinical negligence department and years of experience in this area of law, we are well placed to advise you on your rights to redress. For further information, please do not hesitate to contact us and we can discuss the various options available to you.